My name is Mark Hughes. I'm a faculty member at the Berman Institute and also on the ethics committee of the hospital. Part of my role has been to also help in implementing MOLST that we're going to hear about today. We have the honor of hearing from Jack Schwartz. For over 25 years, he was the Assistant Attorney General for Maryland. Rendered a lot of opinions about advanced directives, end-of-life care. You can still look at letters to the Attorney General where he will respond very thoughtfully to those issues. In addition to his work there, he was the Director of Health Policy Development, so very instrumental in the state in formulating a lot of policy as it interfaces with the legal system. He is now retired, but he is still very active in a lot of different endeavors. He is a member on the Institutional Review Board at National Cancer Institute, as well as on an advisory committee on healthcare-acquired infections in the Maryland Healthcare Commission. He serves on our ethics committee here at Johns Hopkins, as well as at Washington Hospital Center. And he's also on the advisory board for the Maryland Healthcare Ethics Committee Network. He is a very important member of the American Bar Foundation, a fellow there, and served on the American Bar Association's Committee on Law and Aging. Here in Maryland, he's been on the State Advisory Council on Quality Care at the End of Life, as well as the Maryland Stem Cell Research Commission. He served as a senior consultant to the National Bioethics Advisory Commission and is a member of the National Advisory Committee on the Robert Wood Johnson Foundation. He is trained here in Maryland. He got his BA at University of Maryland, Baltimore County, and then went up to Yale Law School for his JD. So we're honored to have Jack Schwartz talk to us about MOLST, and you'll hear everything about what's going on with that. So Jack.
Thanks, Mark. Hello, all. Can you hear me?
Yes.
A ground rule is that there are very few ground rules, which is to say I would much prefer to hear your questions, comments, and sarcastic remarks as we go along rather than waiting until the end. I don't have any money at stake. I doubt that anybody has much money at stake at MOLST. I'm not involved in any aspect of the regulation of healthcare facilities or the enforcement of MOLST. I did testify when the legislation was pending. I testified in favor of it. So I have the customary bias against having to admit that I might have been mistaken. All right, what's MOLST? What am I talking about? Here's the one-slide version of it. It's the abbreviation for Maryland Medical Orders for Life-Sustaining Treatment. It's a standardized clinical order set that's valid across all healthcare facilities in Maryland. One of its primary addressees are emergency medical personnel. So one function of the MOLST order form is to address code status. And it is intended over time that the MOLST document will replace the EMS DNR order that many of you may be familiar with. It's not that those are no longer valid, they are still valid, but the idea is that this will provide the information that emergency medical personnel need when somebody calls 911 in lieu of the EMS DNR order. It contains opportunities for clinicians to address other interventions, and it's a law. It's the law. And the requirement to use MOLST became effective on July 1, 2013. So I'm going to talk about the rationale for this public policy initiative, what has happened as background elsewhere, talk about the content of MOLST, the code status component, and then other possible orders that could be embodied in this document. I'll talk about two aspects of the process surrounding MOLST, that is to say, what happens when I'm mostly going to look at things from a hospital perspective. What happens when a patient arrives at the hospital with a MOLST order form? And then what about writing MOLST orders as part of the discharge process? And in that context, I'll talk about the relationship between MOLST and other aspects of the law and clinical practice, like informed consent. And then at the end, assuming there's time, I will talk about some mixed public policy and ethics issue, which is, this is a government mandate. This is an order to y'all to do this. Is that justified? When is government a government mandate of this sort justified? All right, so MOLST is trying to achieve improved informed consent, especially for patients with advanced progressive illness. It is intended to help bridge the sometimes gap, sometimes chasm, between the language in advanced directives and clinically actionable orders. And given that we are eons away from anything like a coherent healthcare system, it is intended to help smooth out some of the rough edges in transfers of care. I think most folks could agree that these are ethically salient objectives. Of course, it's a question of whether MOLST might actually achieve it. Now, MOLST is the Maryland version of something that now has a couple decades worth of history. In 1991, a project started in Oregon, which culminated in a document called POLST, and most of the literature is about POLST, Physician's Orders for Life-Sustaining Treatment. This started out as essentially a quality improvement project in Oregon, to try to improve the standard of care for people with serious illness. And the success of POLST, at least, well, I'll talk about the evidence for success in a moment, suggested that this was a useful model. And so there is an organization called POLST.org that seeks to promote the expansion of POLST or its analogs in other states. There isn't any federal law on this, mind you, so this is a state-by-state proposition. Counting Maryland, there are 17 states that have a POLST or similar type program. And supposedly in a couple of dozen other states, there is a developing program, whatever that may mean, embryonic or otherwise. So POLST and its variants are already, and increasingly so, going to be part of the landscape. Now, unusually for the Maryland General Assembly or maybe other policymaking bodies, before they enacted the MOLST legislation, there actually was some evidence that might do some good, as opposed to mere hunch. Now, the evidence here, I'm not going to claim is robust. John Ioannidis would not be impressed with this evidence, but still, it's some. It's more than one often has. So this is about POLST, and one study by Susan Hickman and others showed that for nursing home residents, it's much more likely that important issues are actually going to be addressed in orders if they have a POLST form. Well, it's sort of not surprising, actually, because the POLST is an order form and intended to allow for these issues to be addressed. But it seems at that basic level to work. There's a little bit of other evidence that what actually happens to patients conforms to what's on their order form. So assuming a proper process for the creation of the document, the creation of the order set, then it seems at least reasonably likely that what actually happens to patients, the care, the treatments that they actually receive, are likely to be more concordant with their wishes or their proxy's wishes if they have a document like this than if they don't. So in the second study, Hickman again, it's a 98% compliance rate with the orders embodied in a POLST form. So Bud Hammis, who is at Gunderson Lutheran in La Crosse, Wisconsin, and has worked with POLST program and implemented it, and sort of a nationally recognized leader in this field. He's embodied the judgment that this can be a highly effective program to ensure that patient preferences are known and honored at all settings. So the experience so far, at least in Hamas's view, is that this can actually be a helpful device in trying to achieve those ethically salient objectives. Diane Meyer quotes an unnamed California hospital executive as saying that the POLST program in California, quote, makes our lives easier because in his view it helps identify to a much more effective extent than previous endeavors like living wills patient preferences and captures them in a way that makes it easier to implement. All right, so given this background, an effort was launched in Maryland. Actually, there was the first proposal to have a POLST-like document in Maryland. It goes back to 2004, which was unsuccessful at that time. As I know, there are probably still some scars on me about that. But anyway, there's a core group of folks, not including me, the benefits of retirement, this is I don't do things like that anymore, who spent a couple of years in meetings trying to get buy-in for a POLST-like program in Maryland, MOLST. And they succeeded in getting the legislature in 2011 to add MOLST language to the Maryland Healthcare Decisions Act. The effect of putting that into the Maryland Healthcare Decisions Act, which has been on the books since 1993, is, in one sense, it's the logical place for it, but another considerable benefit of putting MOLST in there is that it gives people who use MOLST, who write MOLST orders, who follow MOLST orders in good faith, legal immunity from civil or criminal or disciplinary liability. The immunity fairy sprinkles immunity dust over everybody because of the placement of this provision in a law that has an immunity section that says people who follow the provisions of this law in good faith gain immunity. So that was a smart move and a benefit of doing it the way these folks did. Now, MOLST was not self-effectuating, that is to say, the legislature passed a statute, but the details, including the actual content of the form, required a regulatory process. That did not conclude until December 2012, and the health secretary, I think correctly, wanted to give additional lead time for facilities to do training and adapt their systems to the advent of MOLST. So July 1, 2013 was the date denominated in the regulations for MOLST to become effective in the mandatory sense, though plenty of facilities, especially nursing homes, but also some hospitals, had been using MOLST before the actual requirement date. This is the one-slide version of what's on MOLST, and I will come back to these points in more detail in a few minutes. So MOLST is a medical order. So it has an order with respect to code status, full code, or one or another variant of DNR status. And then, as relevant, it contains orders with respect to these other interventions. As I say, I'll have one slide more for each of these. And I assume the slides will be available later on the website or somewhere. Okay. So you need to take feverish notes. They'll be made available later. Most orders are not supposed to be written at random or on the whim of the morning. Instead, there's supposed to be an actual basis for what's on the document, and that basis is supposed to be stated. There's an actual part of the MOLST order which contains a certification of why did you write the orders the way you wrote them. And most frequently, presumably, that will be because the orders resulted from an informed consent discussion with a patient, if the patient has capacity, or with a proxy, if the patient doesn't have capacity. I'm using the term proxy broadly to encompass anybody who's speaking on behalf of a patient who cannot engage in the informed consent process, him or herself. There's always supposed to be an informed consent process, right? It's just who's on the other end of the conversation that may vary, and that is supposed to be the basis for what orders are written on a MOLST form. It is possible, maybe it doesn't happen as often as some folks would wish, but possible that the patient, now incapacitated, has an advance directive that speaks to some of the issues that are intended to be captured in the MOLST form, in which case the advance directive should be considered, and the MOLST order form should be consistent with the advance directive. It is possible for a clinician to write a MOLST order based on the fact that a particular intervention, say CPR, would be medically ineffective. That's a permissible basis to write a no-code order. The use of MOLST is, at one and the same time, mandatory and voluntary. It is mandatory with respect to healthcare providers in a way that I will talk about later in this talk. But it is voluntary from the perspective of the patient or the patient's proxy, which is to say, if you are my physician or nurse practitioner or physician's assistant, and you engage me in a conversation about MOLST, and I pull out my garlic and say, go away, I have the right to do that. What's the consequence of that? The consequence of that is that I'm a full code, since we have this societal default that says, societal standing order, that says anybody has cardiac arrest, there's attempted CPR. So if I don't want to engage in the conversation, I've made a decision. And I should be told about the consequences of my decision not to want to talk about this. But there is a recognition in the law that not everyone is going to want to cheerfully engage about this. So it specifies what happens.
Jack, if there's both an advance directive and a MOLST, which one trumps the other?
It's, I'll repeat questions to make sure that they're captured. If there's both an advance directive and a MOLST, which trumps? It shouldn't really be a question of trumping. The idea is that if the advance directive addresses the situation as to which one component of MOLST is speaking, the MOLST order should be consistent with the advance directive. So one has to speak of trumps, the advance directive trumps, in the sense that it shouldn't be an inconsistency. Let us imagine the rare but possible living will type of advance directive that says, I want every last medically reasonable treatment done. I want every last minute, second of life that I can get, no matter how miserable I am. That ain't mine, but there are some like that. Well, then MOLST orders should all be oriented toward the use of interventions, because the idea is to do what the patient would want. And if such an advance directive speaks to the situation in such clear terms, MOLST should follow.
But I could imagine a situation where there may be an inconsistency. If the advance directive was written by the person while they still had capacity, but the MOLST conversation occurs with a proxy who has since decided something different.
Yes, well, but that, the question is, isn't it possible that there's an inconsistency between an advance directive written by a patient when the patient had capacity, now patient loses capacity, now there's a proxy, and proxy wants to decide something different, and have that different decision be reflected in the MOLST order form? Sure, that's possible, but that's not any different than the world before MOLST. And the conversation with the proxy needs to take into account what the now incapacitated patient said in the advance directive. If what the patient said in the advance directive is applicable to the current situation and there's no ambiguity about it, then the advance directive needs to be applied. That's the virtue and the vice of advance directives. Back there in the past, I have supposedly considered this future situation and I have addressed it. And now I've lost capacity, so my decision, as embodied in that advance directive, is trapped like a prehistoric insect in amber. But still, at least the ethics of 20 or 30 years ago, and the law today says, let's look at the decision trapped in amber and apply it. So MOLST doesn't change anything about that. MOLST may bring that to the surface, but it's the same as it always has been. What if the proxy wants to do something differently than what the advance directive suggests? And that's an issue or problem in proxy decision making.
I just want to make sure that the last bullet on here is clear to me, that this is no different. It's not as though somebody won't participate in a MOLST discussion, it makes them full code status. It just really says that they haven't participated.
They haven't
And
participated.
the decision is the physician or the people caring for the patient who have to go through the same process about whether or not to make a decision about resuscitation.
Sure, but this supposes that no one will engage, that the patient won't or can't, the proxy won't or can't. What's the default?
But do not resuscitate is a physician's order, not a patient's order.
That's correct, but
So that's
Insofar-
not different.
that's not different. No, there's no difference about that. No, this is in some other states. I think there may be a bullet on a slide later about this. In some other states, patients or proxies sign the POLST order form, and I thought, and said to the legislature, I thought that was a bad idea because it blurs the line between the prerogatives of patients and clinical orders. I didn't think there should be one order that patients sign where they don't sign any other medical orders.
Ironically, there was actually on the Diane Rehm show today a discussion of exactly this, of POLST
Damn, I
orders.
didn't listen to
You were probably en route here, but one of the commentators said during this discussion that her experience with POLST forms in her state had been that most physicians and other healthcare providers pay attention to the POLST form because it is signed by a physician, to get to Maggie's point a little bit, and that they therefore don't defer as much to the older style advanced directives. And I'm wondering if there's data to back that up across the country, or if not, what you think may happen along those lines. Is that a valid concern?
The question is, given the fact that MOLST or POLST is a physician's order, is there a risk that clinicians receiving such an order will give it undue weight as compared to an advanced directive? Are there data about this? Not that I know of. Do I think it's an issue? Yeah, I think it possibly is. I think there may be a misconception that now this thing is the only thing you need to think about or worry about.
So I was just going to add to that, again, this is not data, but you can just look at how we react to the two. You can bring an advance to us, admit, and it doesn't start a chain of events about who has to contact who and let somebody know they have an advance directive. But if you bring us a MOLST, there is a procedure. This person must know, and they must contact the doctor, and they must sign off, and they get a big other thing in their form. We treat them very differently already.
And a quick question about how the immunization would play out here. If you have a MOLST form in front of you, you see it, and it's a fairly low standard to have just simply good faith. It's not really some really searching standard that you have to go look at other things. Would you be immunized against really frank violations of advanced directives with the MOLST in front of you?
Would the immunity provision, the question is, immunize somebody against liability for frank violation of an advanced directive? Depends how frank, I guess. No, I don't think it's good faith to say, yeah, I see what it says, and if we applied this, it would cause us to do something different, and we're ignoring it. That doesn't get you immunity, no. But if you don't know about the advanced directive, or somebody has described it in a distorted way, and you're acting in good faith, and you don't have any reason to doubt it, then you do get immunity, even if it turns out that the order issued is contrary to the advanced directive once it surfaces and people figure it out. There's still a premium on trying to actually get hold of the document if it's available. All right, this is a nice segue to the slide because I do want to emphasize that this is not like, all right, the universe is like Ptolemy described it, and now it's Copernicus's account, and everything is different. No, it's not like that. The whole legal foundation and framework for healthcare decision-making in Maryland is the same as it was before. MOLST doesn't change anything about, I mean, the Berman Bioethics Institute, I don't need to talk much about the gap between the theory and reality of informed consent, but however that may be, informed consent law and practice stays as they are. There's nothing new or different because of MOLST about how one does or how clinicians ought to attend to advanced directives. That all stays the same. There's no change in surrogate authority. Let me make sure I'm explaining what that means. First, terminology. Before, I said I was using proxy as the general term for anybody who's deciding on behalf of the patient. If somebody has an advance directive that names a preferred decision maker, in the Maryland terminology that's called a healthcare agent. Elsewhere that's known as a durable power of attorney for healthcare. I'm not talking about that. That person is empowered under the document. Suppose somebody doesn't have an advance directive, i.e. suppose it's 70% of all the people out in the world. They don't have an advance directive. So they didn't name a healthcare agent, right? Who decides for them when they lack capacity? In the Maryland terminology, that's a surrogate decision maker. And there's a hierarchy. Guardian, if there's one who's been appointed by the court, spouse or domestic partner, adult children, parents, adult siblings, other relatives or friends. See, this is the hierarchy that I'm drawing in the air, okay? Those folks called surrogates or surrogate decision makers have somewhat limited authority with respect to a decision to withhold or withdraw life-sustaining medical treatment. In order for a surrogate to decide, no, I don't want to continue the use of the ventilator, or I don't want a peg inserted, or any other modality that's a life-sustaining treatment, for a surrogate to decide that requires a certification by 2 physicians that the patient is in one of 3 conditions. The semi-magical conditions: terminal condition, persistent vegetative state, or end-stage condition. If a patient has not been certified in any of those, none of those 3, the MOLST law does not authorize surrogates to say, well, I don't want any of those things. It's not an expansion of surrogate authority. It has to be written by those who write these orders consistently with existing law. And existing law limits, to that extent, the authority of surrogates. Are people with me about this? Understand the issue? And the same thing is true about a living will document. If a living will says, as the typical living will would say, if I'm in terminal condition, persistent vegetative state, or end-stage condition, I don't want life-sustaining treatment, keep me comfortable, allow me to die. Okay, typical living will, 96%, I just made that up, of all living wills are like that. So, suppose somebody lacks capacity, does not have a healthcare agent, may not even have a surrogate, you haven't found a surrogate yet, but there's this living will. You can write a MOLST to withhold or withdraw treatment, if but only if one of those conditions has been certified. There's no expansion of prior law because decisions are now reflected in a clinical order set called MOLST. Do you see? It has to work with and be confined, if you will, by prior law.
I want to get your clarification of what an end-stage condition. So an example of a person previously healthy in a motor vehicle accident, comes in as a trauma, has extensive surgery, is now in the intensive care unit on a ventilator or other life-sustaining treatments for an extended period of time. Does that count as an end-stage condition through the law?
People, well, I'll repeat the question. So you got a motor vehicle accident or other trauma, which leaves somebody in the ICU in crappy shape, right? And they're going to be there for a while. I'm using technical terms. They're going to be there for a long while. But my question, I think, in terms of how the definition of end-stage condition is set out in the Maryland law is what's going to happen next. Because the definition of end-stage condition speaks of a progressive condition or illness that will ultimately culminate in death that hasn't reached the point of terminal condition yet. So it's the progressivity that seems like the key element. When the legislature enacted the authorization for surrogates to say no to life-sustaining treatment for people in end-stage condition, what the legislature had in mind, if that's not an oxymoron, is Alzheimer's disease. And so they built into the definition a sense of progressivity. So your motor vehicle accident victim, you have to make a judgment about what's going to happen. And if it's stasis, that's not progressive either. Stasis in a bad condition isn't progressive. Last bullet point on this slide is just the same point reiterated, which is to say Maryland law previously and Maryland law still allows physicians to determine, based on the clinical facts of the situation, that a particular intervention would be medically ineffective. The classic example is attempted CPR is medically ineffective for a patient with widely metastatic cancer who has a cardiac arrest. Okay? MOLST allows that determination to be embodied in a clinically actionable order, but it doesn't loosen the previous criteria. It doesn't change anything about the manner in which, or the definition of medically ineffective treatment. So just think of MOLST as a more, it is to be hoped, effective means of capturing decisions that are made based on the law that's been in place for 2 decades and that has not been changed in any of the material respects that I'm talking about. All right. Here's the, if you blink, you're going to miss a slide piece. I got one slide for every chunk of the MOLST order form. I am utterly incompetent myself to talk in any detail about any of these. So you can ask questions if you wish to engage in a piece of futility. The piece of the document that is supposed to be done for one and all, since we all, like some sort of doppelganger, carry around our code status, is code status. And this is the part that is primarily addressed to EMS personnel. So they know what to do when I'm lying keeled over here and somebody kindly calls 911. Maybe you don't need to do that around here, I don't know. But anyway, so this is whether to attempt CPR or variations on no CPR, but modulated responses to somebody who has not yet gone into full arrest. Respirators. And on each of, or not each of these, but most of them, there is an interesting component, and I think this will serve as a good public education tool eventually, which is that there's not just polarities, there's not just yes, no. There are positions in the middle. Let's try it for a while and see what happens. I'm not sure that too many folks out there in the world have assimilated that concept of the therapeutic trial. And so it's good that MOLST introduces that concept. So it's there for ventilation, not for blood transfusion, which is, I assume, the Jehovah's Witness piece of the MOLST form. You want it or you don't. Hospital transfers, of course, primarily addressed to the situation of residents in long-term care facilities who sometimes, depending on their condition, it may well be their, or more likely their proxy's choice to say, I want to die here. Few people will say it quite that way, but that's what it amounts to. No, I don't want to go to the hospital and experience that which happens to people in hospitals and probably die there. I'm willing to trade off time for staying here in my home. And again, there's a mid position between yes or no. Medical workup, yes, middle, no. I'm not sure why, since the middle one is so sensible, symptomatic treatment and comfort, why anyone would say no, but I guess there's a logic to offering the range of choices. Antibiotics, yes, less nasty, and no. Obviously, there is a provision on artificially administered nutrition and hydration, which allows people, if they wish, to distinguish between fluids and hydration. Dialysis and write-ins. That's meant for things like chemo or radiation. It's not meant for no heroic measures or other ambiguous phrases like that. Okay, now here's something I actually do want to talk about, which is, so what happens when a patient shows up in the ED or other part of this hospital with a MOLST? What's supposed to happen? Well, one point is, don't worry about whether the person whose name at the bottom of that form has privileges here at the Johns Hopkins. It doesn't matter. The form is valid and is to be accepted regardless of privileges or no privileges.
Just point of clarification, that's not true in a state that doesn't have, like if we happen to be hospitalized in Virginia or some neighboring state that might not have one of these laws.
Right, then it's up to the hospital. I mean, assuming there were such a document, assuming it's a Maryland MOLST that comes with the patient, then it would be up to the hospital. And one of the reasons for having a POLST or MOLST program is that it is more important that patients' embodied care plan be recognized than it is to worry about who's got privileges or not. But yes, the answer is someplace else, the hospital may say, well, we don't know if this person has privileges here, and so we're ignoring it. Not supposed to ignore it.
Jack, the Attorney General recently has opined that not only is a MOLST valid with the signature by a licensed provider, an NP, and a licensed PA as of October 1st, but recently we heard that unlicensed house staff can sign MOLSTs.
Did everybody hear this question? I actually have a little bump of a bullet point about this later, but I'll address it now. So the issue is unlicensed house staff. Can they sign a MOLST? For once, it's not the Attorney General's office that gets any blame, if blame is to be applied here. The Maryland Board of Physicians wrote a letter that is available. The Executive Director of the Board of Physicians said that yes, it's true that the MOLST law speaks about licensed physicians and other NPs, PAs, but under the Maryland Medical Practice Act, medical residents, house staff are permitted to practice medicine as unlicensed medical professionals. And in their view, that is the Board of Physicians, and they're the big kahuna when it comes to deciding on these matters. A MOLST form signed by an unlicensed medical professional who is practicing medicine pursuant to that provision of the regulations of the Board of Medicine may lawfully sign a MOLST form. So this is a decision by the regulator of physician practice in the state. Now, their letter also recognizes that it's up to an individual healthcare facility to have its own policies. So if in preparing MOLST order forms on an outgoing basis, if Hopkins decides it doesn't want house staff to sign MOLST orders, I don't think there's anything in what the Board of Physicians said that prevents that policy judgment. But on the incoming end, you're not to say it's not a licensed doc and therefore I'm ignoring it. Not permitted because of the combination of you're supposed to pay attention to the MOLST and the Board of Physicians says unlicensed medical professionals who are practicing under that regulation are permitted to sign. Does that respond to your question?
So it sounds like to me, if we have people coming in with MOLST, regardless of, we have to assume that that signature at the bottom is valid.
You have to assume, unless you know to the contrary, that that person was authorized to sign it and that it represents what they say it represents.
But then on the outside, on the discharge.
On the discharge side,
The hospital can adopt a policy that says no unlicensed.
that is correct. The hospital's policy prerogative has not been changed. That's a question of what you want house staff to do or not do. Yes?
Yeah. Is there an electronic version of the MOLST, or is it just a paper that you need to bring? Is there a repository for that? You know, how does it work?
Is there a current version on paper or is there an electronic version? Yeah, there are both. An electronic version is valid. There's a standard form. It's not something to be altered, but you can print out the paper or use the electronic version. Either is acceptable.
So it's part of the patient's medical record?
Yes, that's correct. It's part of the patient's medical record.
Part of the electronic record though?
No.
Right. So
Well,
not part of the electronic record?
is that a question, whether it's part of the electronic record, is that a question about how bits and bytes work at Hopkins? Or, I mean, if
The question is, what's the repository for the electronic version?
if a facility has electronic medical records, that's the repository, and if it doesn't, it doesn't. I think I'm not understanding this question.
I'll class it a different way. How does a new hospital seeing a patient for the first time do an adequate search for a pre-existing MOLST that might have been issued in another facility?
You don't.
The
You
question-
have it in your hand, you don't.
Okay.
That's right. The question is, what is the search obligation? And there is none. The obligation is on the facility that's sending the patient here to send the MOLST, either hard copy or electronically.
Unless I'm mistaken, I believe they can wear a bracelet with their MOLST information in it.
A comment about the use of a bracelet. The bracelet would contain and be effective with respect to the CPR DNR aspect of the MOLST, but it does not encompass any of the other possible orders that are written on the MOLST. It's just a convenient form of communication to EMS providers. The slide says, and I mean, that when a MOLST comes in, you're supposed to review it for relevance to the patient's current condition. By which I mean, you need to think about it, and you need to talk about it. And I have identified two polarities that I wish you to reject. It is not holy writ. The person who signed that MOLST with the new incoming patient is not some prophet channeling divine ordinances. Nor is MOLST junk email that you can trash without even reading it or thinking about it. It is neither one. It provides useful information. So this is how the patient's doc or nurse practitioner or PA thought the patient should be treated based on the patient's condition at the time that the MOLST was signed, and most of the time, the informed consent process that preceded signing the form. Seems to me that's useful for you to know. And therefore, you should attend to it. So, the question then that I think a clinician who gets a patient with a MOLST should ask, is there a good reason to change these orders? What has happened, if anything, that I should change these orders? Maybe I should change them because the patient's condition has changed. That's often a reason why somebody comes to this hospital, right? Because they're a lot worse than they used to be. Or maybe it's possible that the goals of care have changed. Maybe it's possible that a newly discovered advanced directive has been pulled out of the safe deposit box, or something, a modality that was medically effective no longer is. There could be some circumstance that has changed. So the divine command of the MOLST coming in with a patient is think about it and talk about it with whoever's making decisions, the patient or somebody on behalf of the patient. And if there's a good reason to change it, then change it. And if there's no good reason to change it, then don't. That seems like easier said than done. I can stand here and say these words, and that doesn't mean it's easy for you as clinicians to apply, but I think this is the basic idea behind saying, here's the MOLST with the incoming patient, now what? Read it, think about it, relate it to how your patient is, and what will serve your patient. All right, on the other end, as has already been said, this is the legal mandate is do a MOLST as part of the discharge process. I'm speaking of hospitals now. Nursing homes are, as very frequently the case, under a heavier regulatory obligation. They have to do a MOLST for their entire resident population in long-term care. Hospitals, no. Discharge process for inpatients, where the patient is going to another site of care, basically, other than just home, see you, have a good life. There's an exception built into the regulations, not necessary for psych patients, pregnant women, or minors, other than those who have a life-threatening condition.
Jack,
Second.
can you talk about how these requirements compare to other state POLST laws in terms of application to all patients, except for the ones you carved out?
Yes. So how does the Maryland MOLST, in terms of its scope or sweep, compare to other states? By and large, this requirement is broader. Other states either don't really describe and allow the sort of standard of care to apply, or the application is more limited to seriously ill patients. So this is broader, and I'll talk about in a slide or two why I think that might be okay, but this is controversial.
Jack, can I just ask about the exemption for pregnant women? Something that's supposed to be done at the time of discharge.
Uh-huh.
I'm trying to understand why a pregnant woman somehow stands out as somebody who shouldn't have this conversation. So if I've come in and had my broken leg set, or if I've come in and had some other sort of time-limited treatment, how am I different from a pregnant woman who's, you know, a healthy 25-year-old who's on her way home?
So the question is there really any differentiation between, say, a non-pregnant person with a time-limited condition who on discharge needs a bit of rehab and is going to therefore go through the MOLST process versus a pregnant woman similarly situated who doesn't have to go through the MOLST process? Well, first of all, the hospital's free to apply the MOLST conversation uniformly. I think that you'd have to ask the health secretary that the reasoning here was simply to reduce the burden on hospitals, to try and carve out a segment of the patient population as to whom the bulk of the MOLST orders would ordinarily not be applicable, and just relieve some of the burden on the discharge process.
I thought pregnant women were exempt only if the reason for hospitalization was the pregnancy.
Now that you say, the corrective point was, if the reason for the hospitalization is related to the pregnancy, then they are exempt. I think that's right. I'd have to look at the statute to confirm that, but that sounds right. So if your broken-legged pregnant woman is going to rehab, then there'd be a MOLST conversation, because that's not related to the pregnancy. So I want to differentiate, well, before I do, let me just go through the basics. Completing a MOLST, who does it? Licensed physician, MD or DO, nurse practitioner, PA. We've already talked about unlicensed house staff in the context of the incoming MOLST, so I won't do that again. The document is not just an order set, it's a certification of what the basis is for the orders. So there's a spot on the form, who'd you talk to, that caused you to write the orders in the way you did. Nice that orders are accurate and consistent. Bad to be, full code but no respirator. Sign and date, I already talked about this. No patient or proxy signature. The patient or proxy gets a copy within 48 hours. Now, I think, although this is caricatured dichotomy that I'm about to do, but I'll do it anyway. So what if the patient is seriously ill or frail? And then I'll talk about the, blew out, the 41-year-old who blows out her knee and needs some rehab, but is otherwise healthy. I think that the idea about doing a MOLST as part of discharge planning is to try and understand the goals of care, which requires a robust informed consent process, given the patient's current state of health, write MOLST orders that implement the goals of care, but avoid addressing future speculative issues that aren't currently presented. You're not writing an order for all time. You're writing an order that is addressing currently relevant issues. So a way to think about this is the MOLST order that you write on discharge should try and answer the question, how should my patient be treated at the next site of care, given the patient's current condition and prognosis and the current goals of care? And any one of those things could change, but the change would then be addressed in a subsequent process. So you're not writing an order for eternity. Now, for the pretty healthy patient, I think this is a controversial thing. It's in this question about, isn't the scope of the Maryland requirement broader than other places? Yeah, it is. It is. It's broader than the concept of POLST as it originated. So what happens with somebody who's had a misfortune and winds up in a hospital, but their baseline health is really pretty good. They're easily distinguishable from the systems falling apart patients. The MOLST process there is a little different. Just confirming full code status, because that would be the only thing that would be relevant. None of the rest would be relevant. MOLST does not exist to say, geez, in 35 years, if you can't take in food normally, do you want a feeding tube? That's not what it's for. So it'd be a confirmation of full code status. And I think, actually, the conversation, now this is where people who will say to me, that you're being completely unrealistic. There's not enough time to do the things that we have to do, let alone engage and talk about other things. That may be true. But if there were time, then MOLST is an exercise in public education. MOLST is an exercise in getting people to talk about and think about issues that they don't normally want to talk about. MOLST is an exercise in getting the 41-year-old to start thinking about what's going to happen to their 74-year-old mother. And insofar as we as a society can transfer thought about these issues away from the goddamn television programs and to something grounded more in reality, then MOLST and MOLST-related conversations can help with that. So that's why I think it was not a bad thing that the Maryland legislature broadened MOLST beyond the category of really sick people for whom it was originally created. All right, we have 5 minutes and I have a few more slides. And I'll just mention this. I'm not sure there's going to be time to talk about it. When Oregon started out, it was a voluntary thing. And it took a long time, actually, for there to be any piece of law in Oregon. There's now a regulation of the Oregon Health Department that basically says, you got to honor POLST in Oregon. That took a while. It started out as a voluntary thing. And the Maryland approach is much different. The Maryland approach is a mandate. And I think it's right to be wary of mandates. I think we are seeing increasingly, mandates that affect aspects of the informed consent process. Some of them are simply ideologically driven, like the requirements to convey false information to women before an abortion. But others are, there are such requirements in a number of states where none of us want to live. But others may be more, reflect a more genuine ethical concern, which is, for example, if policymakers think that people facing life-limiting illness are not getting the range of information that they ought to get as part of the informed consent process, left largely, yeah, there's a theoretical threat of liability, but left largely to the discretion of providers. If that discretionary process is seen as not achieving the desired goal, then one response is potentially going to be a mandate. And so California and New York, in my example, have enacted a Palliative Care Information Act, which is kind of command and control regulation. It says you shall tell people the following things, including the option for palliative care. Why did they do that? Because they thought that the voluntary discretionary aspect of things was failing. Here, the desired outcome is that patient care preferences, or the preferences of a proxy, should be identified and respected throughout the healthcare system. I think that's, again, an ethically salient goal. Before MOLST, was that outcome being achieved? I don't have any data. I have impressions. I have the I've been around kind of impressions. I think the answer is no. It was yes in Oregon, it was no in Maryland. For years and years and years, there were EMS, still are, EMS DNR orders that hospitals routinely ignored when patients came in with an EMS DNR order. For years, not years and years, but years, there was a voluntary form, well, mandated for nursing homes, called a patient plan of care form. Did hospitals, by and large, adopt that form as a way to improve the informed consent process? No, they didn't. There were outlier hospitals that did, but mostly they didn't. Did they pay attention to the form when it came from a nursing home? Did it come from a nursing home all the time anyway? No. The voluntary system didn't work very well to try to achieve the goal. And under those circumstances, I think it's legitimate for there to be the legal heavy-handedness of saying, you shall apply. You shall conform. Not that the law leads to actual behavior all the time, but still, there's also sort of inequity here, which is that the more heavily regulated nursing homes tend to do things, and hospitals historically, more lightly regulated, tend to decide whether they're going to do them or not when they want to. So in California, without a mandate, Sugiyama's study about POLST in California shows or reports a significant minority of hospitals remain unprepared 3 years after implementation, especially hospitals in poor areas. Now, one can mount socioeconomic explanations of this, but it means that the patients there are not getting as good care as they would if POLST, in this example, were properly used. So I myself think that there's enough time for discretion. And if the system is going to be catalyzed into providing what has been at least provisionally shown to be a useful document, then it was indeed time for a mandate. All right, so in hospitals, what next? Correct the misimpressions that are floating around about MOLST. I think it's crucial that MOLST be seen as part of a system. If MOLST is seen as the external mandate, then it's the take-up and the actual good faith use will be less than as desirable. But if people say, this is the way we do things around here, meaning the robust conversation and the capturing of the results of that conversation in the MOLST order form, then that will be a systemic improvement. And this is Hopkins gathered data. One piece of information, the Maryland Healthcare Ethics Committee Network is having a conference at the University of Maryland Law School on December 9th, a full day on MOLST, best practices, problems, barriers, etc. There's on the website, there is a survey opportunity. Part of what they want to do is provide the results of an anonymous survey about how people are experiencing MOLST in its first 6 months of the mandate, though some people have been using it longer. So that may be of interest to some of you. And the last slide, again, the slides will be available, just tells you where to find out more. There's a Maryland-specific website called marylandmolst.org that has lots and lots and lots of stuff about MOLST. And there are these others. All right, I think I actually did it by 1:15. I can, I guess, hang around if people have questions, but those who need or want to go elsewhere should depart. Thanks.
Thank you.